Welcome to NeLI Pod, the official podcast of the National eDiscovery Leadership Institute. Here, we bridge the gap between technology and the law, bringing you the forefront of electronic discovery. Hi, I'm Daniel Gold, your co-host and navigator through the evolving landscape of eDiscovery. With over 20 years at the junction of law and technology, I'm excited to help bring together leading experts and practitioners who provide a wealth of knowledge on electronically stored information.
And my name is Brandon Mack. I'm the co-host of our podcast. And with 2 decades of eDiscovery experience myself, I'm also thrilled to be able to participate in bringing you information and education around the world of eDiscovery.
NeLI is not just about discussions. It's about education and it's about collaboration.
Our guests, from judges to eDiscovery professionals, share insights that cater to all experience levels.
Whether you're looking for a broad overview or in-depth technical analysis, this podcast is your gateway to understanding and implementing effective eDiscovery practices.
It's important to note that while we engage with some of the brightest minds in the field, the opinions expressed on this podcast are those of the individual guests and the host, and do not necessarily represent the views of their respective employers.
We're here because of our passion for eDiscovery and our commitment to providing free, accessible educational content to legal professionals everywhere. And welcome back to another NeLI Pod podcast, the official podcast of the National eDiscovery Leadership Institute. And we are really excited to have joined here in the virtual recording studio, the one and only Doug Austin, the founder and editor of eDiscovery Today. Brandon, I think it's fair to say that Doug has really been a cornerstone of the eDiscovery industry for years. And when I say years, it's not just being on eDiscovery Today. It's being in this business well before this was called eDiscovery. So when we actually had, just discovery and paper documents, Doug was there. He was a part of that and has definitely seen the world change when it comes to eDiscovery. He's been providing daily insights, analysis, commentary on the latest trends and case law, and all the advancements that are helping to shape the legal landscape. And I know firsthand that with eDiscovery Today, he has created this go-to resource for legal professionals looking to stay ahead of the curve. I say I know that firsthand because Brandon, like you, I go over to eDiscovery Today and I do subscribe. That is, to be clear, not a commercial or an endorsement one way or the other of eDiscovery Today, but it is a fantastic resource, like many other resources that are out there, to be able to make sure that we understand some of the most recent trends that are happening, and that's exactly why Doug is here today. There's so much happening in the world of eDiscovery. So emerging trends in artificial intelligence, legal technology, something that is often talked about, and Doug just recently talked about it on a webinar, is hyperlinked documents. And what's really interesting is the role that the courts are playing in this world of AI. So Doug's bringing to us today a lot of unique perspective drawn from years of tracking this space closely. Doug, welcome to the show. It's great to have you.
Thanks, Daniel, and thanks, Brandon. Thanks for having me. It's great to be here and looking forward to having some fun talking about eDiscovery trends, challenges, and everything else.
Fantastic. I do miss the days when we used to actually just call it Discovery, Doug. So when you say you've been in this business for 30 years and you really have seen it grow, there's no question. Doug, let me ask you this. You've not only been in the business for a long time, but you've also been blogging for a long time. And as the editor of eDiscovery Today for 5 years now, I'm curious what drew you to eDiscovery, and over the years, both eDiscovery Today, but also being in the legal space and doing some consulting work as well. How have you seen this space shift over the years?
So from a standpoint of what drew me to eDiscovery, I think like a lot of people, it was kind of more happenstance than anything. I had years ago, and it was so long ago, they were considered the Big Eight consulting firms back then. I started working for Price Waterhouse on a large litigation and basically joined their litigation support team group and worked on several large litigations, some large bankruptcies over a few years. Just really, that was my beginning is the lit support background that really, I think, spawned eventually eDiscovery. Daniel, as you mentioned, we could use the term discovery, and at this point, most of the evidence is electronic. So if it weren't for the fact that it would really mess up Google searches to try to search for discovery instead of eDiscovery, it would probably be appropriate to change it to discovery at this point. But from the standpoint of evolving from those paper days where you had all these steps to go through to first copy documents, then scan them, and remove fasteners and slip sheets and this and that and Bates labels, all that sort of stuff, to moving it towards electronic evidence and treating it electronically. It's been very interesting. I've been daily blogging for 15 years now. And I was thinking about this, when I started in daily blogging in September 2010, the Zublake cases were just a few years old. The EDRM model was like 5 years old. eDiscovery was still a relatively new discipline, or only a few years, and we still pretty much equated it with a litigation. Most of the solutions were on premise. The processes for most of the evidence we were dealing with was email and office files, and it was mostly manual processes moving from step to step through the EDRM model to get to them. We didn't have TAR yet. There was no really acceptance of TAR. The Silva Moore case, Judge Peck's ruling was still a year and a half away. And then when you look at kind of where we've gone today, in terms of eDiscovery is about all these other use cases, investigations and incident response and data privacy requests and even HSR second requests. It's really almost equivalent to data discovery in terms of the things that we really apply eDiscovery workflows and technology to. A lot of our manual processes, at least for the traditional data sources, have been very automated, and really, I think, we have, very established practices for those. Our data sources have exploded in terms of now we've got all these sources in the cloud, we've got collaboration apps, we've got mobile devices, we've got, even things like data from IoT devices, or I just covered like a case involving somebody being sued over their ex-girlfriend had an Apple Watch had given back to him when he broke up and gave it to the son, and apparently the ex-girlfriend conspired with a cop, or at least the guy alleges, has conspired with a cop to put him in jail for a hearing, and he was getting all the text messages on his son's Apple Watch because it hadn't been cleared yet. So, stuff like that is just kind of amazing, where we're at today. Now, TAR is kind of like almost old hat, really, to us, and we're talking about all this Gen AI stuff. So it's really, they say that in the short term, progress seems slow, and in the long term, it seems very fast. And when you look over a number of years like that, we really seen a lot of things change. So, one of the things that's, for me, is interesting about eDiscovery is it's never boring. There's always some challenges to deal with. There's always some, new things to learn. And that's why I love what I do.
Brandon, I don't know about you, but I feel like Doug just aged us just now in a matter of just a few minutes, because I've lived through
and myself too. Yeah.
Just a bit, because I too remember the paper days. I remember when it wasn't eDiscovery, it was just discovery, and a lot of it was done on legal pads and then advancing to spreadsheets long before you had review tools that you were actually doing this stuff in. So I'm well aware of how old I am and how long I've been around this stuff. But Doug, you said a lot in your answer there. There are a lot of different individual things about the development of eDiscovery that you talked about. And in the time that you've been in the eDiscovery industry, and even just in the 15 years that you've been documenting the eDiscovery industry with a daily blog, there have been a lot of changes. And eDiscovery it's a multifaceted thing, but I think one of the things that always catches the headlines is the technology that's involved. Because there is that E in eDiscovery, we think about it as a technology-based practice, even more sometimes when we think of it as a legal practice. So when you think about the technology that you've seen evolve over the past 30 years, over the past 15 years, what do you think has been the most consequential thing that you've been able to watch sort of mature and grow up in the e-discovery industry?
Um, yeah, there's that's interesting because there's a couple of things you could point to. Obviously, the evolution of TAR, the introduction of Gen AI, which is really we're just starting to get a sense of what we can do with Gen AI technologies and what have you. Certainly, automation. We've come a long way with automating processes and streamlining workflows. But probably if I were to pick one, I would probably say it's been the cloud because we've evolved from on-premise e-discovery solutions to cloud-based e-discovery solutions as the predominant solutions of choice these days. And our data sources are so much more in the cloud these days. I mean, we've moved from Office on-premise to M365, and Google has evolved and grown as as an Office platform, a Gmail and Google Drive and Google Vault, and then of course all the collaboration apps with Slack and Teams and what have you. Um, so to me, I think the cloud, both from a standpoint of where we conduct e-discovery and also the sources we're pulling from e-discovery, and any e-discovery platform today is pretty much expected to have links and APIs and integration with a number of cloud sources. To me, I think that's a must, and I think that's really probably transformed how we conduct e-discovery more than anything else.
So it's interesting what you say there, Doug, because it has transformed how we are doing e-discovery. It has been that way now for a few years now. And the interesting thing that you're talking about is, so we go to the cloud and then all of a sudden that translates, if I heard you right, that translates into all of these other various different data types that were not there before. And as a result of being able to create all these other data types so easily, now we have data volumes that we didn't have before. And it's very cliche. We've been talking about growth of data. But what you are specifically saying is, as a direct result of the cloud, we've had these increased data types, and now we have all of these new data volumes that we didn't have before, which one would definitely argue makes the cost of e-discovery that much more expensive, because now we have to preserve that data. Now we have to be able to collect all that data, et cetera, et cetera. There's a lot of various different data types that have caused more issues, I would say, than others. Some of them, for instance, ephemeral data. So ephemeral data being, for those that are listening, that is those types of data that you create and they disappear quite literally. So WhatsApp messages or Signal being another very good example. These are messages I could send to you, Doug, I could send them to Brandon, and just like that, they disappear. So those are ephemeral data. Linked files is a very, very complex topic, more complex, I think, that we originally anticipated when we went to the cloud. We were talking that right before the recording. And with the hyperlinked files or modern attachments or linked files, however you want to call it, that is essentially the Google Drive or the Microsoft OneDrive or any other variation in which you are sharing a live file, and quite literally a change could be made. And now we need to go back and collect that version of that document when we sent it out at that particular moment in time. So I'm curious, Doug, what are the challenges that you are seeing that the industry has met well, and where have we really, where have we fallen? Where have we stumbled?
Mm-hmm. Well, yeah, I mean, we're in the big data era. And, I think when people think about big data, it's the three V's. It's volume, velocity, and variety. And we're certainly feeling all of those. I think 15 years ago, there were 2 zettabytes in the world. Today, it's something like 182 zettabytes. And then by 2028, it's supposed to be something like 394 zettabytes. And when you mention all these file types and different sources of ESI, it makes sense. And there continues to be more and more. And I think Gen AI is going to boost that way up because we're generating all this new content. And they still need more content, which is crazy. Definitely, I feel like we're in progress on a lot of them, in terms of how we're addressing them. I think we probably come the farthest with mobile devices because, I mean, 15 years ago, the iPhone was just a few months old, and we were a long way from really getting our arms around mobile devices. And a lot of litigations, the parties would say, okay, let's agree we're not going after the mobile devices because it's just too much, effort, time, cost, what have you. And today, I think we've got a number of different options that can either collect forensically or collect much more streamlined the data that's typically needed in a lot of cases. So I think we've definitely come a long way there. I think with certain collaboration apps, I think a lot of the platforms have developed robust collection capabilities to pull in data and what have you. And I think, things like Slack and Teams and what have you, there's getting to be established processes for those, even though those platforms are changing things, which of course means that then the eDiscovery platforms have to change to accommodate that. You mentioned hyperlinked files. That's definitely one of the challenges that's really causing us to stumble right now because it is so complex. It's the moving from, traditionally we've had the parent-child relationship with the email and the physically attached files in an email, which basically was a good static copy of everything we needed right there, and we had no, worries about it. Now you've got a hyperlinked file that may no longer even exist, or if it exists, you may not be able to get to the version that was sent, or you may not have rights anymore, or what have you. And there's a whole lot of questions about, what's required. Is it proportional? When is it proportional? What do you have to do? And so forth. I just covered another ruling in the In Re Uber case this morning. And there's continuing to bring up, questions about, well, how do we do this? And we never talked about this in the ESI protocol. So that's definitely at the top of the list of, I think, things that challenges that have caused us to stumble. And then I also think that, one of the things we're going to continue to see is challenges. I mean, in a sense, hyperlink files is another example of potentially ephemeral data, but then the whole ephemeral messaging at consideration is another one that right now I don't think we have a lot of good answers for. And I think one of the things that's going to that I don't know if we'll ever see it, but it would be nice to start to see some of these source ESI solutions start to think about eDiscovery by design, where they consider eDiscovery, issues as part of the design of their product to begin with, instead of having to shoehorn it in the back end. But until then, it's going to be a continual minefield of challenges out there for eDiscovery professionals, and certainly is going to provide job security for all of us, right?
And Doug, you mentioned in there that you were looking at an update to specific case law. And, one of the things about your blog is that it's not just about the technology. It's not just about, current goings on in the industry itself, but everything that's driving this is coming from the rules and coming from the bench. And so you cover case law as well in different court cases that you've seen. In 15 years, there's been a lot that's happened in the e-discovery industry as far as updates to the rules, how those rules have been interpreted, how different judges have looked at those rules and applied them to different challenges that we've had within the industry. At the very outset, you mentioned a number of those that were relatively new cases when you first started your blog 15 years ago. So in the time that you've been writing the blog, you've seen a lot of that evolution. What would you say has been the most interesting of the evolution from the bench that you've seen over the course of the last 15 years? It's really guided what we're doing at eDiscovery today.
Well, certainly a case that I think that tends to come up again and again. And I would be remiss if I didn't mention the case of the Honorable Andrew J. Peck, who I do a case law webinar with every month on the EDRM webinar network. But certainly the De Silva Moore case, where that was the first case that approved the use of technology-assisted review, and I think has really kind of established some expectations there that I think also will really establish expectations when it comes to the use of generative AI, because I think that in Civil Moore and also in a couple of other cases, Judge Peck really established, the understanding of, hey, Sedona Principle 6 says responding parties are best suited to respond to discovery in the manner they see fit. And I think that's a good philosophy, and I think that was truly a landmark case that we've referred to again and again. Interestingly enough, we still see disputes about whether a party can even use tar still, which I'm amazed about because we had a couple of cases we covered last year, one of which the judge actually granted the plaintiff's way of going about it to say use tar only after trying keyword search first, which is crazy to me, but you're still seeing stuff like that out there. Some of the more recent cases, some of the recent cases that I'm seeing that I think are indicative, mobile device data discovery has really become much more predominant. And a few years ago, we had the Rossbach case, what I call the case of the smoking emoji, where the plaintiff sued the defendant for sexual harassment and had produced this text message exchange that looked really bad with that was supposedly from her supervisor with a heart eyes emoji. It turned out there were several things when they started getting into the metadata of the text exchange, which she only produced an image of. They really saw a number of issues with it, but one of the biggest issues was that she had an iPhone 5, and the version of the heart eyes emojis she used wasn't possible on that version of the iPhone. So it was like a case where it was literally a smoking emoji the version of the emoji for the iPhone iOS version that supported the iPhone 5 was different. And so those were among the many things that doomed her case. We've seen a few fabrication of evidence cases, and I think that's one area where we're probably going to see a lot more, especially with deep fakes and considerations like that. So I have a feeling Rossbach is a case that's going to probably come up again and again in the future more and more.
The smoking emoji is something I'm not going to forget anytime soon there. I like that. So you said a lot there that I want to unpack, though. One of the things you talked about, though, was the tar cases that are still getting litigated, and it strikes a bit of a chord with me. Brandon has heard me riff on this before as well, and both of us are obviously very big proponents of leveraging technology that works to drive a much more efficient workflow. Makes sense, right? Everything costs less. You get to the heart of the matter much, much faster. My curiosity with you, Doug, is this. So why is it, do you think, that this is still getting litigated today? The question about whether or not to utilize tar, or whether you want to call it tar, you want to call it Cal, or any version thereof, Cal 3.0, Cal 27.0, whatever it is, right? Why is it that it's still getting litigated? Because after all, and Judge Peck, of course, naturally said it, that it's black letter law at this point, but we are adopting Gen AI at much faster rate and saying it's acceptable than we ever have, and still don't with tar. Why is that?
Well, I do also, one of the things that I do is a state of the industry report, and if we get a chance to talk about that, I think that's still to be seen just how fast we're adopting Gen AI. But yeah, I mean, to your question, beats the heck out of me. Unfortunately, in our industry, it seems like, and a couple of other people have mentioned this, not just me, the approach to use keyword searches and manual review seems to be above review. It's just like accepted as a normal way of doing things and doesn't have to be justified or verified or what have you. But with tar, we have to have transparency. And I don't understand, why, because I mean, I've known a lot of attorneys who do not understand keyword search like they think they do, and definitely don't know how to really get to the documents that they, to construct searches that would be maximizing recall and precision effectively. And I think we still have a lot of disputes over keyword searches. But from a standpoint of the fact that it seems like anytime somebody wants to use tar, there's still some disputes about either can they use it or how transparent they have to be when they use it and what have you. And honestly, I think the focus should be on the results. How are they validating? How are they confirming? From my way of thinking, whether you use keyword search and manual review or tar or Gen AI or a divining rod, what were the results? If you can verify that the results were, a high percentage of, recall, and a good percentage of precision, that's to me is what matters. And I think we're looking at the wrong things. We're looking at the how they're doing it as opposed to what the end result is.
In your last two answers, you've said so much. We could spend another hour just unpacking your last two answers.
Sure.
One of the things that you talking about the smoking emoji case. I want to go back to that for just a second. It's something that's somewhat related that you said near the end of that answer when you were talking about we may be seeing more of this in the future, especially now that we're moving into a world where there are deep fakes and different things that you can do to really create fake evidence, and it's accessible to the average person very easily. This is one of those things where I feel like when we look at the rules, we look at the rules of evidence, we look at what the bar and the bench are prepared to deal with. Are we ready for a world in which people can create fake evidence as easily as they can now? And if not, what do you think we need to be thinking about or talking about to get the industry ready for this?
Well, of course we're not ready for it. But I do think that we're doing some things. Certainly, one of the things that I know that has been looked at, and Dr. Maura R. Grossman and Judge Grimm were proposing some new rules changes to the federal rules of evidence related to deepfakes and what have you. Because one of the things that, and they've noted this in a paper, is not only do you have the potential problem of deepfakes, but now you're going to have the potential deepfake defense where people are going to say, oh, this evidence against me was deepfaked. It's not legit. So then, you're going to have that challenge. To me, I think some potential evidence rules changes will help. And then I also think that this may be one of the biggest drivers to how we change form of production in terms of producing evidence. Because I think now metadata and forensics is going to be much more important than it ever is. Getting the data, having a way of validating that the data is legitimate. Metadata is one of the best ways to do that. And forensics, professionals have the knowledge of understanding, the metadata, understanding how to collect and preserve the metadata and what have you. And I think that to help ensure that the evidence we're working with is not deep faked, I think those are two disciplines that are going to become much more important than they already are. And they're already, in my eyes, pretty important already.
It's interesting you mentioned that. We actually interviewed Dr. Grossman on the NeLI Pod podcast recently, and talked about those efforts about the federal rules of evidence and proposed changes to it. And it was obviously, because it was Dr. Grossman, it was a remarkable conversation that we had. But I think that what you're touching on here, though, is something interesting, and it's very much like the hyperlink documents. And that is, Doug, is that what you've touched on is that the more we've advanced technologically, the more we really do need to make concerted efforts to understand the benefits and the risks of all of this new technology. And obviously what I'm referring to and using that exact verbiage is obviously the rules of professional responsibility, at least the model rules. And we know, I believe it's 40 out of the 50 states or 43 out of the 50 states have adopted some similar verbiage there. So if you were to talk to and consulting with attorneys talking about a case that involves Telegram or Signal or WhatsApp, right? And all you have is hyperlinked attachments. How do you make sure that the attorneys that are involved in each of these matters really are up to speed? What's the how do they stay knowledgeable? So for everybody listening, it's, what we're talking about over here it's a lot, right? It really is a lot. And it equals a ton of dollars and cents as well. Just being able to forensically scrape this data, and especially with ephemeral data, you're not going to get the messages, but maybe you can get the metadata, right? And so does the metadata tell you something like the smoking emoji matter? So where do all of us lay people in the world, right, listening to this podcast, where do they go to get up to speed? And if you say your blog,
Well,
I understand, but other places.
well, yeah, of course. Well, I will throw my blog in there, but I'm not going, it's a big universe out there. And I certainly try to cover, what I can. And I would certainly mention eDiscovery today as a resource to check. But there are so many good resources out there. EDRM has a great blog. EDRM also has a great webinar channel and has several webinars a month. ASETS has really good webinars and educational resources. There's conferences you can go to. The
NeLI is
Masters
one of
Conference,
them,
I
by
was
the way,
just in
Doug.
yeah, NeLI's one of them. Yes, I was going to get to NeLI last. I was going to save you guys for last. But I'll mention you first then. NeLI, the Masters Conference has local events all throughout the country throughout the year. And then, of course, Legal Week's coming up soon and what have you. And then, of course, really the companies, the players in the industry, the smart ones really are smart about we need to have a good educational program because educated clients are the best clients. And so there's plenty of great resources from a lot of the providers out there in terms of regular educational content, regular webinars, and what have you. It's pretty hard not to find some resources that get into a lot of the things you mentioned, Daniel. And I think that's one of the things that you want to do is continue. I tell everybody, set aside 5 to 15 minutes a day to read something related to the technology in the industry, and set aside at least 1 hour a month to attend a free webinar. And there's plenty of free webinars out there, and that can push you further along being able to do that. I'll also mention, Daniel, while you're right in terms of that, 40 of the 50 states have now a technological competence requirement in their rules. Only 2 states, as far as I know, still have a CLE requirement for technology. So not backing up, it's one thing to say you need to have it, but then saying you need to train on it is something else. And I think that needs to change. And I think that would be the biggest thing that I think would start to help, push the industry to learning more about the technology, is forcing them to get CLE involving the technology.
That's a good thought. And as you mentioned, of the places that you can go, eDiscovery today is definitely one of those places you can go for that education. As a writer, as an editor, you get to select the things that you're going to talk about in the blog. Having seen all the things that you've seen and reported, all the things that you've reported on, all the different ways that you're able to kind of leverage that knowledge and present it to the industry, what would you say are the key takeaways that you would want to give to practitioners that you hope they pull from all the content that you're creating for them?
I guess really some of the things that I would say is, you really want to stay current with what's going on, which is what I try to do. I mean, I try to find things. I try to keep the moving around the various topics. So it's not like I would say there's one topic any more important than any other, but I definitely say it's important to stay informed. And I also would say that, for example, anybody who's reading any of the blogs out there by now has to, who's a lawyer, legal professional, has to know that there's been a bunch of lawyers that have filed cases with fake case filings that were generated by ChatGPT. If you read that, if anybody read one of those then and saw that, they'd be like, okay, I got to make sure I don't do that. I got to make sure I'm checking my stuff. In fact, they already should be under Rule 11 checking their filings anyway. But, that's an example of something where the more you educate yourself on some of the issues, the more in that regard. One of the hyperlinks files cases we covered was that I've covered is the NRA StubHub case. where they agreed to an ESI protocol, where they agreed to produce hyperlink files as modern attachments before they realized what the technical challenges were in doing that. So, ultimately, fortunately for them, they had a provision in the ESI protocol where they could change it with due cause, a justified cause, and the court let them do that. But understanding before you go into a case what the landscape is, what the collections of your client is, and what sources ESI sources they have. Getting that information and understanding stuff like that in advance is really key to getting a leg up. If you are trying to start learning this stuff when you start the case, you're already behind.
I think that's spot on. I like the way you said that. Speaking of which, Doug, you put together, or eDiscovery Today puts together its annual State of the Industry report. Talk to us a little bit about what the State of the Industry report is for those who have not heard of it, and then share with us a little bit about what are some of the key insights or learnings that you found that may have surprised you when you put the report together.
Sure. Thanks, Daniel. Yes. So the State of the Industry report is a report that eDiscovery Today publishes every year. It is designed to be comprised of two components. One, an industry-wide survey of legal and e-discovery professionals on important topics in e-discovery. And then the second piece is thought leader observations on those same topics. So it's a combination of a couple of different things. We've been producing the report for 5 years. The 2025 report was released at the end of January. We had 551 respondents to the survey and 63 thought leaders providing observations. And, we cover we get into topics like Gen AI, TAR, mobile device discovery, collaboration apps. We asked for the first time this year, should hyperlink files be treated as modern attachments? Interestingly enough, it wasn't a 50-50 split like we thought it would be. We asked 2 yes and 2 no questions, but it was almost 3 out of 4 who said yes, they should, or at least in some cases, in many cases, they should. But of course, should and can are 2 different things, and of course, we struggle with that. One of the questions we always ask every year is what e-discovery challenge are we not talking enough about? In all 5 years, the answer has been lack of e-discovery competence in the industry. So we definitely have a ways to go in terms of education still, despite everything we're doing. Some of the findings that I thought were interesting this year, one was that for all 5 years, we've asked what percentage of cases are you using predictive coding on, TAR, CAL, what have you, and this year there was almost 31% who said they use it in all or most of their cases. And there was about 25% who said they use it in very few or none of their cases. And close to half were using it in half their cases. Not bad numbers. And then when you look at the 5 years of the history of the survey, the last 2 years are the first 2 years where the all or most cases groups were higher than the very few or none cases groups. And these are the 2 Gen AI years. So people saying that, Gen AI is going to replace TAR, well, it hasn't yet. We'll see. It's just getting started. Will it down the road? I don't know. But that's definitely one of the things I thought was interesting. I was very interested in the hyperlink files result because I was expecting more of a 50-50 split. Another thing that I would say that was kind of interesting and eye-opening is while people are gung-ho on Gen AI in terms of their expectations for it this year, I basically like over a quarter expected it to have a transformative effect this year, and 4 out of 5 expected it to at least create new workflows this year. Only 12% were using it on cases, all or most of their cases so far, and 64% were using it on very few or none of their cases. So they're not using it on a lot of cases yet. That may change rapidly, but that was very interesting. So I think it's going to be interesting to see, especially in the Gen AI area, just how quickly we make those leaps in an industry that is historically not quick to make technological leaps.
Doug, we've talked a little bit around this in the last few answers that you've given about how do people, where do they go to get their information? How do they educate themselves? You gave us that basic rule of 5 minutes a day, 1 hour a month. I think there have been a lot of things, especially for young attorneys now, some of them coming into the industry, not working in offices with partners where they're learning shoulder to shoulder and things like that, that make the practicalities of eDiscovery challenging for them to get their arms around. So for someone who's just now breaking into the world of eDiscovery, we understand that there are resources for them to go and learn from, but could you elaborate a little bit more on what you think is the best way for them to really get their arms around what's a very big, very complex practice?
Yeah. So, I mean, I guess it depends on, if they're just really coming into the industry cold. Obviously, we've talked about the educational resources. And then one of the things I think that I've seen, some of the people that I've seen coming into the industry in recent years have really, I think, you can't underestimate the value of making connections in an industry. And of course, in LinkedIn, I've seen a lot of people who connect, and a few people have said, hey, I'm new to the industry. What resources can you recommend? I point them to a few places. I forgot to mention Complex Discovery, another excellent blog that I should have mentioned in the previous question. But I think that's one of the things, making connections, trying to get get yourself out there. Another thing that I would mention is if you're really serious about becoming eDiscovery proficient, consider taking the SED certification program from ACEDS, because that is a very thorough immersion into all aspects of eDiscovery. It's a very good program, and it's certainly something that is, while there's a cost to, for the program, it's very valuable in terms of giving you the leg up and really understanding a whole lot of different aspects of eDiscovery. And I do think that the SED certification has started to become something that organizations look for when they're looking for people with eDiscovery experience. Do you have the SED certification? And I think that can be a difference maker. So those are some of the things that I would say in terms of getting into the industry. A lot of people who get into the industry start out in IT or as paralegals. And I mean, those are the unsung heroes of our industry. They're the people who are doing the stuff that needs to be done and then kind of evolving into becoming eDiscovery experts. And so that, these things can, if you're in that situation, help it even more.
Well, you said something there, Doug, that was fantastic, and that is building up your community of people. And there is a great community out there. And as the old saying goes, your network is your net worth. So it's certainly a great reminder. Doug Austin, thank you so much for coming on to the NeLI Pod podcast. It was great to have you. Loved having your insights, and I know that everyone listening to the podcast is definitely going to benefit. Thank you so much.
Thank you. Thank you, Daniel and Brandon. I really appreciate it. It was a fun discussion.
If you've enjoyed our discussion and want to learn more, don't forget to subscribe to our podcast on your favorite streaming platform. We're here to help you stay on top of the latest trends and developments in eDiscovery.
We'd love to hear your thoughts and questions about today's topic. Reach out to us via our social media channels or email us directly. Your feedback makes our program stronger and more attuned to the topics you care about in the world of legal technology.
Remember, all the resources and insights shared today are aimed at enhancing your practice and understanding of eDiscovery.
Join us next time on NeLI Pod as we continue to bring you expert knowledge and lively discussions. Until then, keep innovating, keep discovering, and keep pushing the boundaries of legal technology. Thank you for listening, and we'll see you next time.